That's right, ladies and gentlemen. We are back. Today is Saturday, May 13th, 2017. And remember, tomorrow is Mother's Day. Don't forget to take care of your moms out there. Wish them a happy Mother's Day. Give them a hug, give them a kiss, give them a flower, take them to lunch, dinner, something. Do something. Take care of them. Okay. We're back here now with super attorney Rick Dodd. Rick, it's a pleasure to have you on again. Let's get that microphone to make sure that you're going to be heard over the airwaves.
It's good to be here. You know, about Mother's Day, there's another big Mother's Day. It's always your birthday. You always should call your mother on your birthday. Thank her. It's a big day for her, too, you know.
Yeah, you were both there at the same time, so I mean,
right.
You're sharing the same experience. One may not remember, but you're both there.
Well, she could tell you about it.
Okay. All right, Rick, we set it up here. We were talking to attorney extraordinaire Benton Ross Watson last week about this penal code, and we decided we were going to discuss it further on this one aspect of it, and that was it's not justified upon how's it termed exactly? It says here the use of force against another is not justified, and we talked about paragraph 2 and then section C here about law enforcement. Do you want to just go right into it and give us your thoughts about that, clarify what it means? And
well, I mean, what you got to first look at is the word unlawful. And whenever the police are making an arrest, generally what they're doing is lawful. So when you get beyond what is lawful as far as what the police are doing, you got to be looking at the word reasonable. So here's the setup. If you have one police officer and he's trying to arrest 3 different men, and they are being belligerent and they are being scruffy and they are resisting, his ability or his right to pull out a billy club and club a couple of them may be more reasonable than if you have 3 policemen and 1 man.
That's a good illustration. I understand it totally. For a simple mind like me, that's good.
And where does it cross the line into unlawful? I think what you got to look at is what can affect an arrest. So if you have someone who is willing to put their hands behind their back or lay on the ground with their hands spread out, unlawful would be the policeman walking up there and kicking them in the groin. Unlawful would be the policeman pulling out his billy club and whapping them a couple times across the back, or maybe taking a headshot at them. I mean, he's being compliant. They're able to make the arrest easily. So it depends on the circumstances as to what is reasonable and then what crosses over the line into unlawful. Now, you said a minute ago, you said something about have your video camera on. Yeah, no doubt about it, because when you get to beyond the point of getting billy clubbed, you know, and hurt and having to go to the hospital and get your head repaired, you wind up in the courtroom for having beat up a cop or whatever you did to protect yourself. In other words, the force you may have used to protect yourself against an unlawful assault that has occurred to you by a police officer. And when you're sitting in front of that 12-person jury who's going to make the determination about those words unlawful and reasonable, you have to remember that in their mind, it makes them very uncomfortable to believe that a police officer did something wrong. So you have a really big hill to climb and get over the top of. You expect to be found not guilty by that jury.
Let me step in here for a second. If that situation happens, and I hope it never does, but you know it does, where a person is in position and they're getting unlawfully abused and you start fighting back, that's almost worse than the initial onset of being attacked by the individual unlawfully, because you know what's going to happen. They're going to get swarmed with other officers. So it's like it's in a catch-22, isn't it?
Oh, absolutely. You know, we see it on TV now a whole lot because of cell phones.
Yes.
And we see it on TV a lot more because police officers don't like cell phones. And you know, the police officers may actually try to arrest people that have cell phones. There was a case that occurred that the U.S. Supreme Court spoke to, I think in 1992, it might have been 1982. And of course, you know, I'm a student of the Constitution because I'm a lawyer. I probably sat in a classroom and took, I think, about 16 hours of constitutional law So I love the Constitution. I believe in all the rights that were given to us, and I believe that they're all sacred, including the Second Amendment. But also I like the First Amendment. I like the amendment where we're able to assemble and talk about our government. I like they're all important. So there's a case where an attorney was offended because he saw police giving a hard time to some gays who were having a rally. And the gays were dressed in leather and chains, and the police officer were systematically arresting them for disturbing the peace. And the rationale was, well, they're marching and they have chains and they have leather, and that is disturbing the peace. The attorney steps up in front of the police and says, "Gentlemen, you are breaking the law. You are doing an illegal arrest because these people are not doing anything to provoke anybody except marching, and they have that right to do under the Constitution." The attorney was arrested and, of course, taken to jail and had his day right, so to speak. But the Supreme Court said that he had that right, he had that freedom of speech, and as long as he wasn't grabbing at the police officer, doing something wrong, that he should be found not guilty. So that's a situation where, you know, the police officers might be doing something wrong, and you know, the Constitution was being protected by someone who felt offended by the fact that police officers are doing what they do. And you got to remember about the Constitution, it was written to protect the minority from the majority. So even though these gentlemen that were marching in the Montrose parade down in Houston with their chains and leather may not be the kind of folks that a lot of the majority wants to hang out with and socialize with, they still have their rights under our Constitution to the equal protection of law. And that's the constitutional part that attorney was upset by.
I can't agree with you enough. I'm totally in the Constitution as well.
I'm still here.
The whole works.
Discussing
I just want everybody to know out there,
on the radio.
the reason, I say this all the time, but it's very important that I say it every time, and that is, I ask questions
they're in the middle of a conversation.
a certain way because there's a lot of variances in responses, and you've got to be aware of what can happen based on your response in a certain situation. Even though a law may say one thing, it may get twisted around or diluted or misaligned, and so we're trying to give you all different aspects of it, especially with a man here, Super Attorney Rick Dodd, who's got how many years, Rick? 30?
35 now.
35 years of experience. I mean, he's been around the block, been around the planet, so he can tell you what's going on. Is this pertaining to law?
Is this going to be about what they're talking about right now, Mr. Johnson?
We got somebody on the line here. Let's see if it'll apply.
Do you want to talk to them about what they're talking about right now?
You want to take the question?
Sure.
All right, ladies and gentlemen, we got a caller. We're going to set it up here.
All right. Well, let me transfer you.
You would agree, though, Rick, there's a lot of potential for danger on this particular section when it comes to law enforcement.
Oh, absolutely. Because they have the guns and they have the billy clubs, they have the mace, they have the handcuffs, they have the jails, they have the judges.
And yeah, you said no. Okay. Mr. Johnson, welcome to the show. How are you doing today?
Hey, I'm doing pretty good there. I like listening to you guys.
Well, fantastic. We appreciate your call. What can we do for you? What kind of question you got for Super Attorney Rick Dodd?
They say it's against the law to shoot someone that comes up in the yard and threaten to kick your butt and stuff. I had an officer over here to tell me that if a guy threatened to come up here and whip my wife for no reason, and I called the officer and he come over here in Rockdale, and he said I had every right to defend me, my wife, and my property. I said, well, I got a shotgun. I pulled it on him. And I blew his legs out, and he said, well, you got the right. You got the right. Is that true?
Well, Mr. Johnson, you are going to cut a very fine hair there, and here is the hair that you might have to cut. There was a case called the Martinez case that came up in front of the Texas Court of Criminal Appeals, which, of course, in Texas is the highest court of criminal matters unless it is then sent to the Supreme Court of the United States. But the facts of the Martinez case were pretty clear. In other words, the Court of Appeals said, well, there was no dispute about the facts that were presented in court. Now, you got to remember, presented in court may be different than what actually happened. because
Yeah.
you know we have their truths, we have our truths, and then the jury has their own truths. But
Yeah.
in any case, the Martinez brothers, Renee and Rudy, they had been gone for one evening, and a couple from down the street happened to come to their home and burglarize it and take their stereo system and several guns, pistols, shotguns, things of that nature. But unbeknownst to the burglars, a couple across the street watched them do this and actually followed them back to their home and watched them unload the stuff into their home. So when Rudy and Renee came back home, the neighbors told them about this, told them the address, and so Rudy goes down and gets himself a shotgun, and they decide to go over and get their stuff back, or whatever they decided to do. In any case, they went over to get their stuff back.
Yeah.
Well, in the process of that, there were a couple of fellows that went with them who were, I think they were driving tow trucks, but they went with them and sat outside and waited. The testimony was only given by Rudy because, guess what, the two folks inside the house had gunshot wounds that caused their heart to stop. One of them had a couple of gunshot wounds in the back of his head. So the testimony basically given by Rudy was that it was self-defense. That he had brought the shotgun with him because he was worried that when he got there would be trouble. Gosh, guess what? There was trouble. And
Yeah, what?
and that the other guys had actually attacked him. In other words, they had made a move beyond just verbal. And this is where, you know, you need to listen because you're talking about the verbal stuff. They talked about verbal.
But anyway, I told the officer I didn't want to kill the guy, but I said I will blow his legs out from underneath him.
Well, when you start blowing somebody's legs out from under them, you can pretty much expect that they're going to die, especially if you do with a shotgun. But that's the expectation. But anyway, back to the story. The Court of Appeals, they were first convicted. Okay, they were convicted of murder, and because they had done a couple other things, I think it was even capital murder. But in any case, the Court of Appeals affirmed that conviction, but the Court of Criminal Appeals overturned it because they said there was no evidence, none, that they had actually gotten the shotgun with the intent to go over and kill anybody. The only evidence was they had gotten the shotgun simply to protect themselves in case there was trouble, which is exactly what had happened.
Okay.
So then
I just wanted to find out.
there's another case that's important to your subject that has to do with a fellow who was called by the neighbor lady. The neighbor lady had apparently, Mary was her name, she was getting beat up on a pretty regular basis by old Charlie. So the fellow, who's kind of a good Samaritan, and his dad, his 59-year-old dad, go over and help her pack up some of her stuff. And while they're packing up her stuff, guess what? Old Charlie, he comes back home and he asks where and he doesn't call her by nice names, is. And they ask him to please leave. Charlie had given his 59-year-old dad a tire checker, you know, one of those aluminum tire checkers, which I guess, you know, that could be a deadly weapon because it would be a club. But in any case, also Charlie, by the way, was using his pocket knife to cut tape and box up the boxes. So you see the stories getting set up. Now, Mary had already told the Good Samaritan neighbor that Charlie was dangerous because he had a pistol in his car. Well, during the exchange between Charlie and the Good Samaritan, the dad walks in with that little hammer in his hand and says, "Charlie, you better get the heck out of here. You're not welcome here. You need to leave. Mary needs to leave. You don't need to beat her up anymore. This is just a bad scene. Get the heck out." Well, Charlie, you know, being not a real nice guy in the first place, says, "Well, I'm just going to kill you. I got a gun out in the car and I know how to use it, and I'm going to take you out. Now you need to leave." So they said, "No, we're going to stay here and help Mary get out of this situation." So Charlie turns around and starts to leave and go back to the car, where the Good Samaritan then pulls his pocket knife out and basically takes his guts out of him. So Charlie continues to try to go to the car, so he gets taken a couple more stabs in the belly. Well, finally, Charlie turns and goes towards another direction, and the young man with the knife then stops. So when they go to court, the young man is charged with murder because Charlie does die from those wounds, and he is convicted. But it was overturned because the evidence was clear, undisputed. There was no question about it, that Charlie was stabbed only when he was making a move. In other words, he was doing more than just verbal provocation. So you can't just shoot him, sir, when he tells you that he's going to do this. But if he makes a move for his gun, and there's that word reasonable, I hope you're a reasonable person, sir. If you've got that reasonable belief that he has a gun and he's moving to get it, then if the jury believes you, you have the right to shoot him.
I want to chime in here. That's why, Mr. Johnson, I'm always pushing and promoting that you must be prepared in training, understanding your mindset, understanding the tools that you're going to use for your defense, understanding penal code. You have to.
Okay.
Yeah.
Thank you a lot.
All right, thank you. Keep listening. And you have to be prepared in all three aspects and blend them all together, because in a situation like Attorney Rick Dodd here is saying, there's if you don't know one, if you know two, but you don't know the third, it's going to get you screwed. So you have to know it all, put it all together, and make sure that you apply the type of force at the appropriate time for the appropriate reason. Otherwise, you're going to be in court spending a lot of money and probably spending a lot of time.
Well, Matt, I think you talked a little bit about it last week when you said that you basically need the training because that gives you the confidence. And when you're in a tight situation like that and you feel confident that you can take control of the situation within a half a second, then you have more time to let the situation diffuse itself.
That is correct. More, yes.
Like the gentleman that just spoke here, I mean, who was ever standing in the front yard, if he were to take about 10 steps toward him and start pulling his gun out, then, you know, that could be the end of it, as opposed to having to take him out 30, 40 yards away while he's still wrapping his mouth.
Right, exactly. All right, well, that was an excellent call. I appreciate people who call in with questions like that. It opens it up into different directions as compared to me just talking here.
Yes, sir, Mr. Johnson. Thank you.
All right, Rick, what else did you have on your list of fact sheets here that can pertain to this Penal Code 931 that you wanted to discuss or make more clear?
Well, I mean, we all remember watching television, the Los Angeles riots right after Rodney King had been beaten. We see now on television situations where young men are running away from police and they get shot in the back. So we know that unlawful force is used. And we know that situations can be looked at in different ways. And it's always difficult for us watching television or listening to the radio to put ourselves into the place of these police officers. But you know, you got to remember they're human beings too, and they have emotions and they have feelings. And when someone is trying to beat on them, the natural feeling or emotion is, I need to beat back on them. So it can happen. It can happen, and we know it can happen. But you know, most of the time it doesn't.
I want to say something that is going to sound kind of weird, but it's true. Okay, and no disrespect to who I'm about to say this to. If I get an opinion from a law enforcement officer, it does not have much weight with me, because there has been too many times when, I'll give you an example. Somebody says, you know, if you shoot him, drag him in the house. You're going to screw yourself if you do that. A law enforcement officer is a defender of the law. He's a recording device. He's all that kind of stuff. But he's not an attorney. He doesn't know the ins and the outs, and he may give you bad direction or bad guidance unless it is strictly clear, black and white. It's a red light and you drove through it. You're in violation of the law. Okay, so when somebody comes up to you and says, well, you know, you just do this, I know what I'm talking about. No, study it. Go find it out yourself. Otherwise, you're going to find yourself in a predicament that you don't want to be in. Would you concur with that, sir?
Sure. Because, you know, it's just like these cases. There are fine lines, and you know, some opinions can fall on one side of the line and some on the other. I mean, after all, you look at this one where the Court of Appeals, who had 3 judges who supposedly have all the intelligence in the world, so to speak, but basically they have a lot of people writing what the case law before them say. They get to look at all the facts and get to determine them in a matter of months as opposed to a matter of seconds. And they came up with the wrong opinion, according to the Court of Criminal Appeals.
I want to ask you a question about that. Does a judge actually read it all? You know, when they passed the Obamacare, nobody read it. They just said, well, we're going to vote for it. How much time does a judge apply to reading everything so that they can be totally informed? Because I know me, if I was a judge, and I got 24 hours in a day, and I got family, and I got chores, and I got all this other kind of stuff that I've got to do, and other details within the confines of who I am and what I do, how much time you actually got to read that?
Well, you know, in any business, you got people that are going to be good and not so good, okay? I would like to think that all the judges out there in the world are good, but in my 35 years of experience, I can tell you it just ain't so. I think they all do the best they can with what they got, and what you just described, family, things, other things to do. A lot of judges are very popular. They want to be invited to dinners and what have you. And then also, you know, the caseloads can be different. I've been in court where there's like 5 or 6 cases set up for docket call, and then on other days I've been in court where there's 15 or 20. So I think they do the best they can, but I don't think they can read it all, no. But in the appellate situation, they all have understudy attorneys whose job it is to just read this stuff and sort of put it into bullet points, if you may. So the judges that actually sit up on the bench 3 at a time, or, you know, in our U.S. Supreme Court 9 at a time, they have access to all this extra help. Briefing attorneys, people who write the opinions for them, ghostwriters, so to speak, so they can go back and do it. But I'm telling you, being a judge like the district court in these counties, that's a tough job, because I've sat there so many times, and when the first lawyer gets up and makes his 30-minute oral argument after he's turned in an 1.5 inch brief, I'm sitting there thinking, man, he is right. I don't see how the other guys had a chance at all. Then the other fellow or lady stands up and gives her passionate 30-minute argument after she's turned in a 3-inch reply. And I'm going, wow, I think she's right. I don't see how the other guy could possibly win.
Bottom line, stay out of court.
They did. But you know, the judge has to make a decision based on all that, and it's like, wow, I'm glad I don't have that job. It's that's a tough one.
Rick, we have competitions, and actually, we just had let me sidebar this. We had our round robin competition yesterday. Fantastic, lots of. I mean, we got shooters coming up from these competitions that are getting very good. Had one who was in here and has done probably about 5 or 6 of them. Started off rough and won. He won his little revolver. So, great thing. The reason I'm bringing that up is, when I compete into these things, in these round robins, you've got all these different guns that you don't know, you don't see, particular problems that may arise that you're not aware of. But because of my expertise in the field that I do, I'm able to juggle the mistakes or the problems and still come out in time, with accuracy, win the program because of the experience. Would you not suggest that a person, if they need an attorney, they need somebody who can, because of everything you say in the court, that he's got an excellent presentation, but she's got an excellent presentation. You need some attorney in there who can jump through the hoops and on the fly and do it at a moment's notice, as compared to someone who may know law black and white, but may not be able to adjust or respond quickly enough to something that happens in the courtroom that's unexpected.
Oh, absolutely. You know, and you also need an attorney that knows some of the justices. And what I don't mean know them personally, like go out and have drinks, but I mean have the experience to know what that judge is thinking, has read a lot of their appellant briefs. So if I take a case up to the U.S. Supreme Court, I'm not going to be the one to stand there and argue that. I'm going to get some of the guys up in D.C. to do it on a regular basis to help me with this. And that's not an uncommon thing. We actually have appellant specialists, board certified appellant specialists. And depending on, of course, the importance of the case, I've argued cases in appellant court here in Texas, but you know, generally they're personal injury kind of cases where the question is very simple. The other side lost, and they just want to appeal. The state of Texas, for instance, always appeals any case where we get more than their limits. The limits in Texas, may be 150,000. So if you get a verdict for more than that, they got to pay 150, and they have, in my opinion, a standing order to appeal every single one of those cases. So those are fairly simple, not that big a deal. But when you get into some of these bigger areas of concern where public policy might dictate that we decide one way or another, and there's going to be about half the people on one side and half the people of the world on the other, you need somebody in there that kind of knows what to expect from each one of these different judges.
Now, can you give a 10-point list of if a person needs an attorney, what it should be? And I think that 10-point list will be your phone number. Why don't you try?
Well, again, I've been doing it so long that probably about 80% of the people that call us, I give them information that helps them find another attorney. Because I'm not going to, for instance, I'm not going to do what Ross Watson does. I'm not going to go down to the courthouse and take a murder case. I've done those. I've done those in the past, back in the first few years of my career. But I don't feel competent to do a murder case right now. Now, I might sit with another attorney to do the murder case if there are a lot of facts involved that need expert witnesses, because we do a lot of expert witnesses in my field. But if you wanted to call us, you could call us at 800-460-0606, or you could look on the back of the phone book, or look us up under respectforyou.com.
And we got a link on the website, the radio page. If you want to go to aaronsgunshop.com, go to the radio page. We got a link there for respectforyou.com, and you can check out Rick and what he has to offer there. Rick, we got maybe about 2 minutes left. Anything you want to close up, wrap this thing up here about this whole topic? We went all over the place, but maybe you can pull it back in.
Well, it may take more than 2 minutes. You got more than 2 minutes?
No, sir.
Okay. Well, there's the theme of plates. One thing I want to talk about a little bit was there was a case where a fellow was holding a plate, and he was told that they weren't going to serve him there at this particular establishment, and the actor knocked the plate out of his hand. The court said that the plate was an extension of his body, and that was an assault, because the defendant knocked the plate out of this gentleman's hand. And the reason I wanted to bring that up is because I know that we've talked about the gentleman over in Temple who made a lot of media, CJ, and I wondered why the gun that he was holding was not an extension of his body under the same law that we were looking at here, the Texas Court of Criminal Appeals.
Because it must have been a Friday, and
must have been a Friday. Must have been yeah.
There's all these different the personality of whoever's listening, the attitude of the judge. Who knows?
And of course, the lawyers that represent him were good lawyers and all. I don't know. I can only assume that they knew about this case. Ross and I had talked about it. But, they may have had other ideas, and they may have decided that it was a better track to take a different road than try to get a defense on that.
All right, Rick, time is up here. One last time, tell everybody how they can get a hold of you. It's respectforyou.com. And what are the phone numbers?
1-800-460-0606, or right here in Cameron, 697-4965. But just ask around. I've got a lot of people out there that know me and that I've represented in the past. They'll tell you that we do a good job. We care about our people. We don't treat them like numbers. We've worked on cases pretty much all over the United States, and we got a lot of experience doing what we do.
Well, I'll tell you what, if anything happens to me, expect a phone call. I got you on speed dial.
Thank you, sir.
All right.
We'll take care of you.
All right, ladies and gentlemen, we're going to take a break, and when we come back, we're going to go over our topic of interest. Rick, thanks again for being on, and we'll talk to you soon.
You're welcome. My pleasure. Thank you, folks.
Can't believe you died.